All right, guys, we've got some more articles. So let's get into it.
Hello, and welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it.
All righty. Good morning, good afternoon, good evening, wherever you guys are, as I like to say. All the different time zones. We've got some fun time zones. We've got Virginia, as we often do. Hello, Annalie Finch from Virginia. We've got Catherine Brady, from Western Australia. Mantha Johnny from Montreal. We've got Katie CT from the sunny CT shoreline. I believe that's probably Connecticut. Leon Singh from England. Welcome, guys. Welcome. So happy to have you guys here. And we've got another fun Johnny Depp topic. I know that every once in a while we've got some folks that will be in the chat or in the comments saying, "Stop talking about this case. This case is so over. This is like, it's so done with. Why are you still talking about this? Move on to other cases." And to that I say, we have plenty of content on this channel talking about Marilyn Manson, talking about Vanessa Bryant, who, by the way, is going to trial in 2 days. So there's going to be some content coming out for that. There's going to be content talking about a lot of other cases that we're tracking as well. So if you are sick and tired of Johnny Depp stuff, you don't need to watch this. That's totally fine. There's plenty of other content on this channel that you can watch as well. So, and I see a bunch of more other people here from Illinois. Let's see, we've got Illinois. Natalie Wisco from Wisconsin, of course. Good to see you, Natalie. Sandy Ramirez from Savannah. We've got someone from Boston. Brenda Farrow. Good to see you. Nea Cortial, I'm so sorry if I'm mispronouncing your name, from France. You guys, this is awesome. I love it. I love seeing all these folks from all of these different places. And it's great. UK, we've got Sussex. Awesome. Love it, guys. Okay. So let's get into this because, as I was saying, it has been a minute since the verdict, right? And so the fact that this topic is still ongoing. Folks are still writing about it. And the way in which the mainstream media is talking about the unsealed documents, which came out several weeks ago, right? So now there's been time, you can dig through them yourself. Andrea Burkhart's website is linked in the description below through, you can go through the document that I specifically linked to. But you can go to andreaburkhart.com/documents. So the like I said, the specific document that we are going to be using today is linked down there, but you can just, anyway. And for some reason, my neighbor is doing construction next door. So I hope you guys don't hear any buzzing. If you do, I apologize up front. I just heard that. Of course, the moment that I go live is when they decide to go ahead and start drilling whatever they're drilling. Hopefully that doesn't last long. Anyway, so the problem is that we keep seeing these articles coming out where folks are misunderstanding, misinterpreting, misstating, not giving a full picture of various aspects of this litigation process. And so sometimes you just need to have someone explain the process a little bit and to give some context here. So what we're going to do is we're going to go through a couple articles, and then we're going to go through some actual documents that were from those unsealed documents. And specifically for this particular question, that is, of course, in the title and it's in the thumbnail for this video, is the question of did Johnny Depp try to use a revenge illicit material tactic? In other words, did he try to just display photos, images of her nude body for the world to see, just to try to abuse her or take advantage of her? Did he try to do that at trial? We're going to go through that because as you will see in these articles, that is a statement that is essentially still being represented out there. Okay, let's do it. All right, we're starting with Newsweek, where they talk about how Law and Order SVU is apparently their new season is going to be taken entirely from headlines or something like that from the last year. So this is Law and Order SVU trying to jump on the trend, and as many other people are doing. I don't fault them for that. Because a lot of people are talking about it, and there's a reason why this kind of a case has really captivated a lot of people, and it's not just because it's two celebrities, right? There's a lot there that people are very interested in this particular case. So let's read the article itself. And this came out on August 5th, so this is a relatively new article still. All right. Law and Order Special Victims Unit looks to set Sorry, guys. It's a Monday. Let me rewind that a little bit. Law and Order Special Victims Unit looks set to take on the Johnny Depp and Amber Heard court battle with a storyline centered around what looks like an explosive courtroom drama. New set photos from the long-running crime show hint that the series is gearing up for its own take on the celebrity blockbuster trial. Mariska Hargitay was photographed filming the show on August 4th in New York City alongside actress Julia Goldani. Julia Goldani tells, guys, I'm so sorry. I'm totally fumbling over my words this morning, or afternoon or evening, whatever time it is, of Bunhead's fame. The photo show Hargitay as Captain Liv Benson escorting Goldani Tellis as yet unknown character out of a courthouse surrounded by people holding placards with slogans like Team Austin and I Stand with Austin. Another placard reads Team Kelsey. And there's the photo. Sound familiar? Law and Order SVU is undoubtedly garnering inspiration from Depp and Heard's recent multi-million-dollar defamation trial, which was at the center of a media frenzy. Are they going to call this a pivot? Side note. Will Newsweek call this a pivot? Will the Washington Post call this a pivot by Law and Order SVU? Is anyone going to accuse them of that? I would like to know. Sorry, that's a little bit of side shade for your for your day. Okay, anyway, back to the article. During the trial in Fairfax, Virginia, several Depp supporters were photographed outside the courthouse with similar signs. The phrase, I stand with Johnny Depp, has also been a popular social media hashtag. Law and Order SVU is due to return to screens for its 24th season in September on NBC, and it's no surprise that recent current events seem to be making their way into the show. The synopsis for the upcoming season reads, Captain Benson and her NYPD squad fight for justice in cases ripped straight from the headlines. The Depp Heard trial continues to be the subject of ongoing coverage, with the legal proceedings of the former married couple back in the spotlight this week after more than 6,600 pages of court documents were unsealed. Depp was enjoying a newfound career boost in surge in popularity after the trial, but now documents that were not shown in court have been published online containing a plethora of new revelations, and they do not show Depp in a favorable light, says Newsweek. The revelations include Depp refusing to wear a mask during Heard's deposition, Depp's texts to Marilyn Manson about Heard, and his attempt to use Heard's stint as a stripper against her in court. I don't know if you guys can hear the drilling. I'm sorry, guys. Again. Okay. So this, and I also should pause for a second to note that there's a lot of points that people will probably be disagreeing with in these articles. And lot of points that I disagree with in these articles as well. But just to keep this organized and kind of narrowly tailored, I'm going to keep it just on this point right here. So this is the one point, because otherwise we could spend hours and hours and hours. And I want to keep it limited to this one discussion. So there's some photos from the trial. Okay, following the televised trial in Virginia that concluded in late May, the jury ruled largely in Depp's favor on June 1st, awarding him $10 million in compensatory damages and $5 million in punitive damages. Heard, who had countersued for $100 million for nuisance, was awarded $2 million in compensatory damages by the jury. The punitive damages against Heard were later reduced from $5 million to $350,000 under a Virginia law that caps such damages. And that, I think, is the end of the article. Okay, so, but we do have this point about Johnny Depp attempting to use Heard's stint as a stripper against her in court. Okay, let's see. Is that actually true? But before we check that, we will go through another article that just came in this weekend. Let me share my screen again. Alrighty, this is one of the things, one of my gripes with StreamYard. Okay, here we go. Rolling Stone. Johnny Depp stands rushed to fork over cash for unsealed court docs. Did it backfire? Fans of the actor crowdsourced thousands of dollars to see unsealed court documents that contained even more allegations and embarrassing claims against the former couple. Okay, get ready for this one, guys, because this is going to be quite a bit. And actually, before I do this, James Marcel, thanks so much for your super chat. Says it's okay. You get a free pass. You get a free. It's a Monday pass. Thank you. I appreciate that. Thank you. Very kind of you. So, okay. So that's fine. First we had the article from Newsweek about SVU, Law and Order SVU, that they're going to be filming all this stuff. Who knows what they are going to do with their interpretation of this trial? We'll see. We'll see. It'll be very interesting to watch that when it does eventually come out. But now we're going to go through this one. And this one, the reason why this article actually came across my screen was actually because they had quoted Emily D. Baker in it, who, of course, we all know and love. So we'll get to her quote in there. There's a few other attorneys that are quoted in here. So, well, okay. Anyway, let me just read through it, and I'll give some commentary as we go along. As Amber Heard and Johnny Depp both prepare to appeal the verdict in their mudslinging defamation trial, a newly unsealed document dump reignited the frenzy over the highly publicized trial. The mayhem around the 6-week trial, which Depp specifically requested be televised, was nearly unprecedented, even when taking into account that people would naturally be interested in two high-profile actors airing out their dirty laundry. Depp had emerged the winner in the court of public opinion even before the verdict came down, with fans stationing themselves outside the Virginia courthouse in hopes of getting a wave from the Pirates of the Caribbean actor. But 2 months after the trial's conclusion, Depp fans and curious minds are still eager to consume anything related to the case. So much so that last weekend, they helped raise more than $10,000 in a matter of hours to fund the $3,300 cost of recently unsealed trial documents. Okay, this came out 2 days ago, so this is already inaccurate because the crowdfunding didn't happen last weekend. How long has it been? When did I first comment on this? Hang on. Okay. So it's been over a week since the documents were republished. In other words, since Andrea Burkhart put them up on her website. And so it took a while for those to be mailed. That happened quite a while ago. This crowdsourcing. Definitely wasn't just this past weekend. Okay. Anyway, so there's already a little bit there is just factually inaccurate. You can just see for yourselves by going onto Twitter, right? While an initial analysis of the document dump, more than 6,600 pages, doesn't seem to do Depp any favors, four legal experts tell Rolling Stone that what people are seeing are all the explosive allegations and potentially embarrassing claims that Depp's lawyers successfully kept out of the trial. Right. And they don't say, of course, that those were left out of trial with good reason. Okay. Let's continue. What do these attorneys say about this? Absolutely, it was worse for Johnny, Brett Ward, a New York family attorney, says. Johnny Depp's team won some key pretrial legal rulings. Overall, because he had better rulings during the pretrial portion of the case, the stuff that he kept out hurts him more. The totality of the material now looks worse for him. I mean, it depends on what you mean by how like things looking worse for him. If it looks worse for him in terms of liability, no, it doesn't. I very much disagree with that. If you talk about the material looking worse for him because things are being taken out of context, I would very much agree with that. If we're talking about the Depp and Manson text messages between one another, I think that there's a lot that is innuendo and inside jokes from what I have seen, which actually kind of makes some sense. Now, when we are talking about actually another point that I will just interject here, pausing the reading of the article. I have had some folks saying in one of my recent videos about this subject, about Depp v. Heard, saying that I have become very biased in this case. So there's a difference between being biased and then having an opinion based off of information. And I will say that on this channel, I always start a case neutral. Any case, including Manson v. Wood and Gore, right? So even though Manson has come up in the Depp trial, and I have very clearly come to an opinion in the in the Depp case, and I did have a fun time with Manson's name coming up in the trial, that doesn't mean that I have made any kind of a decision one way or another in the Manson case. So, anyway, but in this particular case, in Depp v. Heard, we literally watched the entire trial. Like, what else is there to go off of other than the evidence that came in at trial? The evidence was very clear. The evidence was the decisions that were made by the judge, I think, were very fair. And so I don't think that I should have to defend myself if I have a very strong opinion in this particular case. And so the information that is coming out in the unsealed documents, even if at first blush, some things look very uncomfortable because we are talking about, we are talking about the, stuff that was kept out at trial. That doesn't mean that it was improperly kept out. It doesn't mean that it was bad for him in terms of liability. Maybe in the court of public opinion, some people don't like that, but there was a lot that came out at trial that people didn't like or normally wouldn't like anyway. We literally were swimming in a sea of drugs and alcohol for 6 weeks, right? Johnny Depp does drugs, Johnny Depp drinks alcohol. Johnny Depp does drugs, Johnny Depp drinks alcohol. This is something that in a lot of cases would be very damaging for a single party, for that to come out that they use and abuse a certain substance so much. But in this particular case, there was so much that came out that could be damaging, but for him ended up not being that bad. Okay, so anyway, so these, like, the information that has come out so far about potential ED, erectile dysfunction, other stuff like that, it hasn't really moved the needle for me particularly. So, but as for other cases, I know that anytime Manson's name comes up in the context of Depp v. Heard, I say Manson the boogeyman. And why is that? Because it didn't make any sense for them to bring up his name in this particular case. It didn't. It really didn't. And I know that there are text messages between them that were kept out, and so people are trying to say that this is that they were trying to hide his connection to Manson. No, what they were saying is they were saying that they did not want people to make a conclusion on Depp based on a conclusion that they have already made on Manson. And that's because there's a long history of people making a particular conclusion about Manson. Columbine is one. It's a very clear example that then later on, like when you look back on the accusations that he somehow caused an event like that, today you look back at that on that, and that's laughable. So, but he in the past has been a very easy target. Whether that is what's happening in the case between him and Wood and Gore, I don't know. It could be, it might not. Okay. That's all. I'm going to step off from that little stump, and then we'll move on with the article. Okay. All right. I wonder, maybe should I do this? Yeah, let's do that. That's a little bit bigger. Okay. Okay, moving on. I think it would have been naive for anybody to think all these motions were only going to have flattering things for Johnny Depp and unflattering things for Amber Heard, legal analyst Emily D. Baker says. I always expected it to be both sides slinging mud at one another because that's what pretrial motions are. 100% I agree. 100%. But that doesn't mean that everything that has come out has been overwhelmingly bad for Johnny Depp, in my opinion. But I mean, the words that Emily said here in quotations, I 100% agree. The way in which that it's being couched now with the rest of the tone of the article makes it seem like she's suggesting that this is all very damaging for Johnny Depp, when you can't necessarily take what she said to that particular conclusion. People have their minds made up about the two of them after the trial, entertainment and media litigation attorney Dan Rosansky adds. Based on what I've seen so far, I don't know that anything really moves the needle in terms of changing public opinion. I think I would agree with that. At least that's for me anyway. Now, in terms of the public at large, we'll see. We'll see if this still holds up. Andrew Burkhart, a lawyer in Washington state who had garnered 50,000 YouTube subscribers from content primarily devoted to covering the trial, raised the funds by asking her Twitter followers to pitch in so she could purchase the documents. Burkhart said in a statement provided to Rolling Stone that she donated $7,000 in leftover funds to the Children's Hospital of Los Angeles and Art of Elysium. Judge Penny Azcarate ordered for all previously sealed documents be unsealed last month, essentially opening the floodgates to all the explosive allegations that both sides had tried to include in the trial. In this matter, both litigants sued one another, thereby opening themselves up to the public forum of a jury trial. Court records are public information, Azcarate wrote. The trove of papers mostly contains pretrial discovery motions where each side duked it out over what would be permitted into the trial, with Depp winning several key points of contention, including the omission of details about his friendship with shock rocker Marilyn Manson. Beyond his alleged drug use with Manson, Heard's team had tried to pull in more of the men's texts where Manson called his current wife an Amber 2.0, according to the documents. Depp's team had wanted to keep all mention of Manson out of the case, referring to the serious claims of physical and sexual abuse against the musician, claiming Heard was trying to, quote unquote, smear Mr. Depp under a guilty by association theory. And to be clear, that doesn't necessarily mean that Johnny Depp's attorneys were in any way in any better position to determine whether or not Marilyn Manson, or Brian Warner, as he's legally known, is guilty of any kind of DV himself. So that is an important point to note. Just wanted to put that out there. Their argument just was that they understood that Marilyn Manson's name has been kind of negatively portrayed in the media recently. Recently and over time, let's be real. He's not a mainstream likable guy. At least by the mainstream is what I mean. The court papers also give more insight to Depp's strained relationship with Disney. Even before the studio dropped him from Pirates of the Caribbean 6 in 2018, his former agent Tracy Jacobs testified in a deposition that a Disney executive had called her up when Depp allegedly appeared on TV drunk and stoned and asked her what the hell was wrong with your client. That doesn't necessarily mean that they were willing to fire him or going to fire him or planning to fire him or even thinking about it. So they may have had a strained relationship, but they may have still said, hey, you know what? We still want him because he's Johnny Depp and he's bringing in a lot of money for us. Jacobs ultimately testified about Depp's conduct, as did his ex-girlfriend Ellen Barkin, who told the court about Depp's alleged drug use during their relationship in the late 1990s. But a claim she made in a 2019 deposition about Depp allegedly giving her a quaalude the first time they had sex never found its way to court, according to the unsealed filings, probably because it's entirely irrelevant. And the reason why I say it's entirely irrelevant is because I don't have the page pulled up from that particular portion of her deposition, which was cited by Amber Heard's team. But I do remember seeing that she says he gave me one and then said, oh, well, okay, let's go to the next paragraph before I continue. He came on to me in the living room of my house, pulled me onto his lap and said something like, oh, come on, Ellen, or whatever. Barkin said in her deposition. I protested a little and then not too much. And that was that. Later adding, he gave me a quaalude and asked if I wanted to F. She doesn't say here, notably, that he forced it on her. She doesn't say that he tried to sneak it to her, that he tried to surreptitiously put it in a drink or in food or anything like that. It seems like what she's saying is he said, I have this, you can take it, let's do something. Is that particularly gentlemanly? No. But does that mean what they want it to mean? I don't know. I don't particularly think so. The filings show the Depp's team had tried to get the judge to sign off on using nude photos of Heard and highlighting her past as an exotic dancer, while Heard had tried to refer to Depp's medications to suggest he had erectile dysfunction. So, I mean, power to them in this particular sentence for also saying what Amber Heard tried to get in that, you know, was very personal or whatever that she tried to use. However, we're going to go through Johnny Depp's side of this particular conversation about the nude photos and her as an exotic dancer. Is it true or is it not? We'll find out soon. Unsealing information regarding Depp's alleged medications was surprising to Baker, who had been following the trial closely on her YouTube channel, as Judge Azcarate had kept under seal both parties' personal information, including their medical history. Los Angeles attorney Ryan Baker says Depp's team appeared to have the upper hand due to clever legal maneuvering, such as Depp's team fighting hard in pretrial motions against having him undergo a psychiatric evaluation, which Heard had done. I take issue with this phrase clever legal maneuvering because it sounds like what they're suggesting here is, oh, he's being so clever. Like clever legal maneuvering, like as if like, ooh, they have used some sort of a method to get him out of something that he probably should have been in. In other words, this information probably should have come in. This psychiatric evaluation probably should have happened, and yet it didn't because they were clever. I take issue with that a little bit. Let's read on though. Then they get some direct quotes from Ryan Baker. Amber Heard made emotional distress or post-traumatic stress an issue in the case because she made that an issue. She had to submit to a psychiatric evaluation. Exactly correct. He says, referencing a clinical psychologist testifying that she had diagnosed Heard with borderline personality disorder. That's pretty damning. Then you are waiting for the other person to get up and say something about Johnny Depp, but Johnny Depp never got evaluated because he never had to submit because he didn't make emotional distress or post-traumatic stress in any kind of issue in the case. Exactly. You open the door, you allow that allows the other side to evaluate, to rebut your claim. You open the door by making a particular claim. So we've said this before, and I'll say it again. The reason why she had an independent medical evaluation was because she claimed that she had PTSD as a result of the things that she says Johnny Depp did to her. Johnny Depp never made that specific of a claim of harm. He made claims of harm because he had to. Otherwise, the case would have been dismissed at a very early stage for not meeting that particular essential element of that kind of a claim, of a defamation claim. You have to allege harm. But because he didn't do it with such specificity that he's claiming that there's some kind of a condition particularly, he didn't open that door in the same way that she did. The same goes with Heard's team accusing Depp of modifying photos of his bruises and handing over snippets of chopped audio recordings. During trial, the court heard how the actress allegedly edited images of her injuries, but claims of Depp doing the same thing never gained the same traction. Texts between Heard and Depp's former assistant Stephen Duders about Depp allegedly kicking Heard in 2014 weren't permitted into court, despite the exchange being used in Depp's failed libel trial against British tabloid The Sun. And of course, we've talked about the modified photos, quote unquote, that Johnny Depp received from Amber Heard. That is in these papers as well. I said I wouldn't get into these other claims, but it's like as I read through them, I'm like, I have to I have to say it, right? I have to talk about they're spitting some untruths, or at least they're not contextualizing enough, and it's angering. Hey Nate, good to see you in there in the chat. Happy to see you here for live. Each of these wins played a role in how Depp's team was able to successfully shape the case to their benefit months before heading into the trial. A lot of court cases generally come down to the quality of legal representation, Ward says. Well, that is also true, technically true. Oh, sorry, Uncivil Law. I didn't see you. No, I'm happy to see you too, buddy. Happy to see both of you guys. Anyway, I think they both had very good reputations, but I think some pretrial releases went Johnny Depp's way that helped him. That is true. But even so, you can say, though, legal representation is part of the reason why Johnny Depp won, but he also won because he had a better case. Those pretrial motions, I mean, Judge Azcarate also, she could also see through a BS argument, even if the other side is not making their best argument as well. So she's a very astute judge based on this, like what we saw of her decision making throughout the trial. Baker offers that Heard's team had some big wins by keeping details of more damaging testimonies and declarations out of court, including from Jennifer Howell and Heard's sister Whitney, noting those details were tightly and narrowly constrained. All attorneys agree the fight between Depp and Heard will drag on, as both have notified the court that they plan to appeal their respective verdicts, with the likely possibility of Heard using some of her pretrial discovery that didn't make it into the trial as part of her basis for an appeal. Already, Heard has complained that she had a binder worth of years of notes dating back to 2011 from the very beginning of my relationship that were taken by my doctor, who I was reporting the abuse to, that were deemed inadmissible at trial. How could they make a judgment? How could they not come to that conclusion? Heard out of the jury's decision. Interesting that they note that in here, because I do know that Andrea Burkhart has some great videos on these unsealed documents as well, and she notes that she looked for those notes in the file, right? Because if they had tried to admit them through a motion in limine, they would have been at least referenced, if not attached as an exhibit for us to see, right? If they had tried to admit them through a motion in limine, are they in the file? Andrea Burkhart says no. Now, of course, there's 6,600 pages in this particular chunk of documents. So there could always be some possibility that they're there and somehow, Andrea missed them or something. But I do trust Andrea's diligence, and I do trust her research. I trust that she would not have said something so concretely without having really checked first. So I very much trust that Andrea says that those notes were not in the file, which means Amber Heard talks about how she's got these binder worth of years of notes that would have been like the linchpin of the case. They would have been the thing that made her win this particular case. And yet her attorneys didn't try to admit them. So is that Johnny Depp's fault? I'll give you a hint. No, I'll give you the answer. It's not. It's not Johnny Depp's fault that Amber Heard's team didn't try to admit certain evidence that Amber says would have been crucial. You know what that would be ripe for? If those actually were crucial, that would be a good basis potentially for a malpractice claim. So cool. Just a note there. Do they mention it here? I don't know. Let's move on to the next paragraph and see if they do. Both parties have until September 5th to file their official appeals. Oh, no, they don't. They don't talk about those documents. The fact that they're not even in these unsealed documents, and so therefore they weren't. No one made an attempt to admit them. Okay, let me get back to reading. Both parties have until September 5th to file their official appeals, with their award payments on hold until they learn if their appeals will move forward. Heard has made clear that she can't afford to pay Depp the $10 million in damages, recently selling off her California home. Reveling in his redemption, Depp has joined TikTok. Why do they keep talking about him joining TikTok? Why don't they talk about him going on tour with Jeff Beck? I don't know. That's just whatever. Okay, and oh, never mind. I guess I should have finished reading the sentence. Whoopsie. Reveling in his redemption, Depp has joined TikTok and gone on tour with Jeff Beck to promote their new joint album 18. Still, there's been no signs of an official comeback for Depp on the acting front. This may not be over in the court of public opinion, more importantly, in the opinion of Depp's employers, Rosansky says. I don't know, man. If overwhelmingly the majority of people say that they believe Johnny Depp in this particular case, as opposed to Amber Heard, and they're like very enthusiastically pro Johnny Depp, I would tend to believe that there's a market of people that would like to see him in movies. Anyway, now let's go on to the actual documents, because of course these articles here, they don't show you when they talk about these unsealed documents, the information that's so damaging for Johnny Depp. They don't actually like reference the specific documents, of course. So that makes it a lot harder to try to rebut the claims that are in these particular articles, because they're a bit more, let's just say, impressionistic about the way that they write about these 6,600 pages of unsealed documents. But let's go through some concretely, right? Let's go through the nitty gritty, and we're just going to go through one motion in limine. Well, particularly one opposition to a motion in limine. So this right here is Johnny Depp's opposition to Amber Heard's motion in limine number 6 to exclude evidence of the following irrelevant personal matters. Okay. And this was filed on March 28th, 2022. And so that you guys are fully aware, if you want to read along in your own side tab or whatever, I have the document linked in the description below. And this is page 53 of the PDF. So you guys can read along with me so that you don't, so that no one can say that I'm trying to bamboozle you or take anything out of context. So, and to explain, I guess, speaking of context, to give just a bit more context before we dive in. So what we are going to be looking at here is Johnny Depp's opposition to Amber Heard's motion in limine. Basically meaning that what happened before this document was filed, Amber Heard filed a motion in limine, basically saying there's evidence of certain matters that we deem to be personal, irrelevant matters. They're not relevant to this particular case, so therefore we should keep them out. Johnny Depp's side filed an opposition to that motion in limine. And so then the judge looks at the papers and ultimately comes to a conclusion. And we can see the conclusion based on what we saw at trial, because if you're watching this, you probably also watched the trial with us as well. And we watched every single minute of that trial from day 1 to day 24 or whatever, 28. I don't know. It was like 4 days a week times 6 plus a couple extra. So yeah, like 26. Lawyer math, right? Someone check my math on that. Anyway, so that's what that is. Motions in limine. And let me first go in and say that there is a difference between the discovery process and this process right here with the motions in limine, right? Because in discovery, what the two sides are doing is they are trying to get information from one another, and they have a very broad net that they can scoop up this information from the other party. Like information that is, and I've talked about this before, of course. So if you are watching this and you've watched my other videos talking about this subject, I apologize if this is getting repetitive, but I feel like it bears repeating that the discovery process is incredibly broad. And oftentimes when you are a litigant, the other side is able to ask for information from you that is invasive, uncomfortable, right? If you are making a claim for economic damages, the other side is allowed to ask for sometimes tax documents, pay stubs, all kinds of questions about your income and where you're getting your income and stuff like that. So you open that door by alleging something, they are able to get as much information as possible that could lead to information that is admissible. Doesn't need to be admissible in order for them to get it. So when I say that it is broad, it is broad, the kind of information that they can request during the discovery process. Now, does that mean that they can admit it into trial? No. That is much more tailored, and it's tailored by the rules of evidence. So things like hearsay, things like character evidence, things like I don't know, all kinds of things. I'm blanking right now. But there are a whole bunch of rules of evidence that you can take entire courses on in law school, and in fact I did. A lot of law students who become lawyers have taken evidence as a specific course, and they will usually be about the same between state court and federal court, but with some twists here and there. Okay, with that explanation out of the way, let's get to this opposition to the motion in limine to see what Johnny Depp's side has to say about these nudie pics and stripper history and whatnot that these articles are saying he was trying to have admitted into trial or to try to use at trial. Yeah, let's do it like that. Okay. Okay. Ms. Heard's motion in limine number 6 should be at least partially denied, and the court should reserve its decision on the remaining issues until such time as the evidence, if any, sorry, what if any, is presented, which at this stage is believed unlikely on most of the issues covered by the motion. Mr. Depp does not currently anticipate introducing evidence of one, nude pictures of Amber Heard, though it is possible to envision a scenario in which such photographs might become very relevant in the context of this case, for instance, to show a lack of visible injuries, as a result of which the court should not finally resolve this issue in limine. 2, Whitney Henriquez's past romantic relationships prior to 2011, or 3, Miss Heard's stint as a stripper or rumors that she was an escort early in her career, and it should be noted that Miss Heard has not cited any exhibits on Mr. Depp's exhibit list that relate to those issues. Okay, so important point here, right? That we are like right off the bat that we are saying here is Johnny Depp's lawyers said the nudie pics, Whitney Henriquez's past romantic relationships, and Amber Heard's stint as a stripper or rumors that she was an escort, they weren't intending to introduce those. They say that in the motion in limine, and they note, they're like, hey, by the way, that's not on our exhibit list. But we didn't put it on our exhibit list because we didn't intend to introduce any of that. Where were they trying to admit this stuff? Where's the evidence of them trying to admit this stuff? All they're saying so far is that they said, well, there actually could be a particular scenario where it's actually relatively relevant that she's got nudie pics because she's talking about injuries, which actually they have a point there. But they said it's not even on our exhibit list. Why are you like, what? Like, where is this coming from? Okay. Anyway, continuing on. However, Mr. Depp reserves the right to use such materials to the extent that they become necessary on rebuttal. And in any event, trial is a fluid process, and these issues are all at least potentially relevant and should be reserved for final decision at trial. Makes sense. Makes sense. If it becomes necessary on rebuttal. In other words, if Amber Heard herself opens the door, that's what that means. If she brings it up and they say, well, there's evidence that says otherwise, then we should be able to admit that information, that evidence, which makes perfect sense. In any kind of a case, that makes perfect sense. Ms. Heard attempts to dismiss the reality show video clip as unrelated to domestic violence, but it is directly related. In Virginia, the term relevant evidence is defined as evidence having any tendency to make the existence of any fact and issue more probable or less probable than it would be without evidence. The reality show video easily meets that standard of evidence. In the video in question, however, Miss Henriquez's friends are gathered around her, apparently inspecting bruises on her face and neck caused by Miss Heard. This video may be relevant, for instance, to impeach Miss Heard and Miss Henriquez, who have denied that Miss Heard has ever been violent with her sister. It is also relevant to assessing their credibility and may be relevant for other reasons also. In any case, the court need not and should not resolve this issue at this stage and should wait until such time, if any, that such evidence is presented in the context of the trial to make any rulings. Did I miss a paragraph? Ah, oh my God, you're right. Sorry. UJ Tube, you're right. Oh, I totally bungled it. Sorry, guys. I'm a professional here. Whoopsies. Okay, let's read this second paragraph right here. Mr. Depp specifically reserves the right, moreover, to introduce evidence of one, Miss Henriquez's reality show video clip discussing and acknowledging Miss Heard's physical abuse of her, and two, Miss Heard's past romantic relationships. After all, Miss Heard has 3 of her former relationships on her witness list: Elon Musk, James Franco, and Tasya Van Ree. That kind of makes sense too. It kind of makes sense too. This last part that they're like, if she's putting them on her witness list, why can't we ask about them? She's the one that is putting them at issue after all. Okay. Anyway, thank you, UJTube. I appreciate that. And now let's move on. And it'll go more into depth about these other that second point. Mr. Depp also reserves the right to introduce evidence concerning Miss Heard's past romantic relationships. Indeed, such evidence is put directly at issue by Miss Heard's own allegations, and moreover, is not prejudicial so as to warrant an in limine ruling. For one thing, Mr. Depp cannot avoid referencing Miss Heard's prior relationships, given Miss Heard's witness list, which includes at least 3 individuals she is known to have seen romantically. For another, there is nothing inherently prejudicial about a past relationship that requires an in limine ruling. And notably, Ms. Heard consistently references Mr. Depp's past relationships throughout this case. For example, one of Ms. Heard's allegations is that Mr. Depp physically abused her after she made a comment about Mr. Depp's former partner, Winona Ryder. Additionally, Ms. Heard has testified to hearing about a made-up physical incident between Mr. Depp and former partner Kate Moss. Ms. Heard's past relationships are potentially quite relevant. For instance, Ms. Heard has alleged that Mr. Depp's supposed jealousy of one or more former partners was a motivation for abuse, potentially requiring Mr. Depp to address that at trial with respect to Tasya Van Ree and others. Ms. Heard's motion should be denied and a decision reserved until trial. So, ultimately, I think that she ended up winning out on this one because of the fact that, obviously we didn't have anything come in about her stripper days or her rumored escort days. We didn't see any nudie pics. But again, none of those were actually even on the witness list or on the exhibit list. So those things were not requested to be admitted by Johnny Depp's side. So 100% this is false. 100% what these articles are saying about the nudie pics and about the stripper days is false. So, okay. You guys saw it for yourselves, guys, right here. And you can also, like I said, you can pull up the document. You guys can see that the PDF page, I'm on page 55 now. And that is that. Are there any exhibits to this? No. Okay. Filed under seal. Nope. Yep. This is the next one. So there's no exhibits to this one, but that is about that. What do you guys think? Can we maybe put a fork in this particular idea, right? About the nudie pics and the stripper past. It just seems like this is a little bit ridiculous that people are trying to claim just based off of the fact that she filed a motion in limine to try to keep those things out. It's like they saw that and then they said, oh, he must be trying to get that stuff in. He must be trying to get revenge prawn in. That's what he's trying to do. He's trying to abuse her through embarrassment or whatever. So anyway, okay. That's about it. That's about it for this one. I hope you guys enjoyed this. If you did, please do like the video on the way out before you do leave, because it does help get this pushed out into the YouTube algorithm. If you want more people to see this, this little bit of truth here, be sure to like it so that, like I said, all that engagement is very useful for the YouTube algorithm so that they push it out to more eyeballs. Okay. Anyhow, like, share, and subscribe, of course. Okay, whatever. I'll see you guys in the next video. Okay. Have a great rest of your week or great start of your week. I'll see you guys soon.